Thank you for joining us for our Dying Without a Will presentation. My name is Allison. I'm a team member with Barry Law Offices. This video presentation is on the importance of having a power of attorney in place. There will be a short video on Charles and his wife Anna and the effect of an accident on them and their children. Following this short story, Scott Barry will give a presentation on the importance of having a power of attorney in place. We at Barry Law Offices would like to thank you for joining us for this series on power of attorney.
Anna also never had a power of attorney or a healthcare directive prepared. Thus, a conservatorship and guardianship had to be set up on her behalf. A power of attorney and healthcare directive could have been drawn up appointing an agent to act on Anna's behalf in the event of her incapacitation. Instead, Anna's two sisters began to fight bitterly as to whom should be the one to make these decisions. Since an amicable agreement could not be reached, the court appointed an independent conservator and guardian, which became quite costly. This independent person, who had never met Anna and was paid by her estate, made all of Anna's healthcare decisions and paid bills on Anna's behalf for 4 years until her death.
Now, in this case, what had happened was there wasn't a power of attorney, there wasn't a healthcare directive in place. And if there's not a power of attorney in place, then there's a conservatorship. There's a court-appointed conservator who manages your assets. And with the conservatorship, all that information, number one, is public. Okay? Number two is there's absolutely a cost, because you got to hire somebody like me to go and assist in that process. A lot of times what I also see is that everybody thinks, you guys have other kids? I'm going to pick on you because you started answering questions or asking questions.
Yeah.
But you guys have other kids, and all the kids think that they're the best kid in the whole wide world, right? And they're better than all the other kids, right? And that's not true, right?
I'm not liking this. It's okay, Barry. No,
I'm just teasing. My point being that I have seen it way too many times where when something like that happens, there's a lot of people that think that they can handle it. Okay? And so there's a fight that happens through the courts and trying to determine who is the person that makes the responsibility. Now, in some counties, and it's interesting to see, but some counties will actually appoint an independent conservator or guardian to manage the assets, and because of the fighting. And if an independent conservator or guardian is appointed, number one, a normal conservator or guardian gets paid, but an independent conservator or guardian even gets paid more. They get paid anywhere from, I've seen it from $50 to over $100 an hour for the work that they do. And what we're talking about, the work that they do is pay your bills, deal where you live, all those things, manage your assets. And so putting these things in place, power of attorney, healthcare directive can avoid that. Well, will is different than power of attorney. Will is only effect upon your death. Whereas a power of attorney, the powers in the power of attorney cease upon your death. They're no longer effective. There's a misperception that the power of attorney continues after you die. There's also a misconception that a will, while you're still alive, takes care of it. Okay. So let's talk about a little bit about power of attorney. First of all, power of attorney appoints another person to act on your behalf to manage your estate and to pay your bills. It's limited to financial transactions. They cannot make, with a financial power of attorney, medical decisions. Only financial decisions with a power of attorney. And the power of attorney allows the person to sign on behalf of you if you become incapacitated or incompetent. And it also can avoid, like we talked about, the need for a conservatorship, or a court-appointed conservator. Now, if there is fighting that does happen and someone does petition the court for a conservatorship, the person that you name as your power of attorney is going to be more than likely the conservator. So then you have control of who that person is, and it will stop a lot of the fighting. All right, so who to appoint? Who should you appoint for this? Well, typically you appoint your spouse or some other family member, and again, someone that you trust to deal with your finances. It can be a friend, someone with good with finances again, and somebody that won't abuse the power. That's really important. The power of attorney does have a lot of power because they can deal with your finances. They can deal with those type of transactions. They do have a fiduciary obligation, meaning they have an elevated obligation to make sure that they act on your behalf and they don't start squandering the funds or using the funds for themselves. But they still have the power to do bad things. And then finally, someone that'll look out for your best interests. And I always say it's name successors and at least 3 successors. When you're doing your wills and your trusts, your power of attorneys and healthcare directives, and putting together your estate plan, you're planning for a worst case scenario. So it's important to take that opportunity to name successors, meaning that if the first person can't do it, then you have a successor that can walk in, step in, and take over that duty. All right?